हॅलो गाईज, वेलकम टू इझी लिगल लॉ. आपण पाहत आहोत रिअल इस्टेट लॉज. आजच्या व्हिडिओमध्ये आपण पाहणार आहोत द महाराष्ट्र रेंट कंट्रोल ऍक्ट 1999. The Maharashtra Rent Control Act provides a comprehensive legal framework for the forfeiture of tenancy and the recovery of possession. Unlike general property laws, this act is highly protective of tenants, meaning a landlord cannot evict a tenant simply by giving a notice. They must prove specific grounds in a court of law. When can a landlord recover possession? Section 16 is the eviction engine of the act. A landlord is entitled to recover possession only if the court is satisfied that one of the following ground exists: fault-based grounds, tenant's conduct, damage to property, the tenant has committed an act that causes permanent damage or injury to the premises, contrary to Section 108(o) of the Transfer of Property Act. Unauthorized construction, if the tenant has erected a permanent structure on the premises without the landlord's written consent. Nuisance or annoyance, if the tenant or any person residing with them is guilty of conduct that is nuisance to neighbors or has been convicted of using the premises for illegal or immoral purposes. Unlawful subletting, the tenants has sublet, assigned, or transferred their interest in the premises without a valid contract or legal permission. Non-user, the premises have not been used by the tenant for the purpose for which they were let for a continuous period of 6 months without a reasonable cause. Bona fide requirement, landlords need personal use. The landlord reasonably and bona fide requires the premises for occupation by themselves or any person for whose benefit the premises are held. Repairs and demolition. The premises are required for immediate repairs that cannot be done while the tenant is there or for the immediate purpose of demolishing the building to erect a new one. Recovery of possession from licensees. Section 24. In Maharashtra, live-in license agreement are common. Section 24 provides a fast-track remedy for landlords to recover possession of residential premises once the license expires. Duty of licensee. On the expiry of license, the licensee must deliver possession. Damages for overstaying. If the licensee fails to vacate, they are liable to pay double the license fee as damages until they are evicted. Competent authority. These cases are not filed in regular court but before a competent authority which must decide the matter expeditiously. Conclusive evidence. A written agreement is considered conclusive proof of the facts stated therein. Special cases. Service tenancy. Section 22. If a landlord provides a house to a tenant specifically because the tenant is in their service or employment, the right to stay ends the moment employment ends. The landlord is entitled to recover possession immediately upon the termination of service. Section 15. Notice requirement and arrears. Before filing an eviction suit for non-payment of rent, the landlord must follow a strict process. Demand notice. Serve a notice in writing demanding the arrears of rent. Grace period. The landlord cannot file a suit until 90 days having passed since the service of the notice. Tenant's protection. If the tenant pays the arrears plus interest within 90 days, the landlord cannot evict them on the grounds of non-payment. The comparative hardship rule. In cases of bona fide requirement, the court will not grant an eviction decree if it is satisfied that greater hardship would be caused by passing the decree than by refusing to pass it. The court often looks at whether the landlord has other properties or if the tenant can find alternative accommodation in the same area. The Maharashtra Rent Control Act 1999, which came into force on March 31, 2000, is the definitive law governing the relationship between landlords and tenants in the state. It replaced a fragmented system of older laws to create a unified modern framework. Historical background. The evolution of rent control in Maharashtra is a story of shifting from temporary wartime measures to permanent social legislation. The first generation wartime origins, the first rent control measure in India was introduced in Bombay in 1918, immediately after World War I. It was temporary response to the acute housing shortage and the profiteering by landlords who were charging exorbitant rents during the inflationary aftermath of the war. The Bombay Rent Act 1947, following the World War II, the Bombay Rents, Hotel and Lodging Rent House Rates Control Act 1947 was enacted. It was meant to be a temporary fix but was extended over 20 times over the next 50 years. This act frozen rents in at 1940s level known as standard rent, which eventually led to the deterioration of old buildings in Mumbai because landlords had no financial incentive or means for maintenance. The Malp Vishwanath Acharya case 1998, Supreme Court of India in this landmark judgment ruled that keeping rents frozen at 1940s level was unreasonable, arbitrary and violative of the constitution. The court directed the state to enact a new law that balanced the interest of both parties. Unification in 1999. Before the current act, three different laws existed for different parts of the state: Bombay, Vidarbha, and Marathwada. The MRCA 1999 unified this into one single statute for the entire state of Maharashtra. Object of the Act. The preamble and the structure of the Act outline four main objectives: unification and consolidation to merge the three different regional rent laws into one simplified statewide law. Tenant protection to protect tenants from exploitation in the form of arbitrary rent hikes and indiscriminate eviction. It ensures that a tenant can only be evicted on specific legally proven grounds. Fair return for landlords. Under the older law, the 1999 Act allows for an annual rent increase, currently 4%, and further increases up to 15% for improvements or heavy repairs. This encourages landlord to maintain their properties. Encouraging new construction by providing a summary procedure for recovering possession in certain cases, like live-in license. The Act aims to encourage owners to put their vacant properties back on the rental market without the fear of losing them forever. Application of Act Section 2. The Act is specifically designed for urban areas, does not apply to all properties equally. Geographical scope. It applies to all areas mentioned in Schedule 1 and 2 of the Act, which includes all major municipal corporations and councils. Premises covered. It applied to premises let for residential, commercial, and educational or storage purposes. Exemptions. Section 3. The Act does not apply to premises belonging to government or local authorities, premises let to public sector undertakings, statutory corporations, or banks, premises let to private limited or public limited companies with a paid up share capital of 1 crore or more. The Maharashtra Rent Control Act 1999 governs the relationship between landlords and tenants in urban Maharashtra. However, the law does not apply to everyone equally. To ensure that protection is given only to those who truly need it, the Act includes specific provisions regarding its geographical applications and exemptions. Application of the Act Section 2. The Act is designed primarily for urban and semi-urban areas where the demand for housing is high. Geographical scope. It applies to all areas specified in Schedule 1 and Schedule 2 of the Act. This includes all major municipal corporations and municipal councils. Purpose of letting. The Act applies to the premises let for residence, education, business or trade or storage. Historical continuity. It also applies to areas that were previously governed by the old laws. State power. The state government has the power to issue notification in the official gazette to extend the Act to new areas or exclude existing ones. Section 3. Exemptions from the Act. Section 3 is the most litigated part of the Act because it lists the entities that cannot claim protection under rent control. If a premises is exempted, the relationship is governed by the Transfer of Property Act 1882. which makes eviction much easier for the landlord. Statutory exemptions, Section 3(1). The Act does not apply to government premises, any premises belonging to government or local authority like BMC or Pune Municipal Corporation. Government as tenant premises requisitioned or taken on lease by the government. Banks and public sector undertakings, any premises let to banks, PSUs, or corporations established under central or state acts. Corporate entities, this is major category. The act does not apply to foreign missions or international agencies. Multinational companies, MNCs, private and public limited companies having a paid up share capital of 1 crore or more. The logic, large companies and banks are considered financially strong enough to negotiate fair market contracts. They do not need social protection or rent control intended for common citizens. Discretionary exemption, Section 3(2). The state government can specifically exempt certain types of premises from all or some provisions of the Act, provided the rights of existing tenants are not adversely affected. Premises used for public purposes of a charitable nature. Premises held by public trust for religious or charitable purposes. Premises belonging or vested in a university established by law. Section 5, cessation of exemption. An exemption is not always permanent. If the statutes of the tenant changes, the act might start applying again. If a premises was let to a company with a capital of 1 crore, but the company's capital later fall below 1 crore, the exemption may cease and the company might theoretically seek protection. If a government leased property is handed back to a private landlord and then let to a private individual, the act applies immediately. Section 7 of Maharashtra Rent Control Act 1999 provides a specific definition that form the legal foundation for interpreting the rights and obligation of parties. Understanding these terms is crucial as the Act's protections often hinge on whether a person or property fits into these specific categories. Landlord, Section 7(3). A landlord is defined broadly to include more than just the property owner. It includes any person who is currently receiving or is entitled to receive rent for any premises. This applies whether they receive rent on their own account or on behalf of other, such as trustee, guardian, or receiver. It also includes licensor who has given premises on a leave and license basis. Section 7(15), tenant. The definition of a tenant is expansive and includes those who continue to occupy the property after the original agreement ends. It includes any person by whom or on whose account rent is payable. Deemed tenants, person who were recognized as tenant under previous law like the 1947 Act. Subtenants, only those to whom the premises were lawfully sublet. Family successors, if a tenant dies, the tenancy passes to any member of the tenant's family who was residing with them at the time of death. In the case of commercial premises, it passes to family member who are working with the tenant in those premises. Licensee, Section 7, Subclause 5. A licensee is someone in occupation of a premises under a subsisting agreement for license in exchange for a fee. Key execution, the definition strictly exclude paying guest, family members, or person in the service employment of the licensor. Status, unlike a tenant, licensee does not have a vested interest in the property. They only have a personal right to use the premises for a fixed period.